Okay, our third and final case for today is McDowell versus State of Florida, number 2024-1148.
May it please the court, counsel. Good morning. In this capital case, Mr. McDowell is appealing from his sentence of death following the conclusion of his penalty phase in 2024, which ended in an 11-1 death reg. We've raised several issues on appeal, but as this court's aware, the first two of these are already pending before this court, those involving the retroactivity of the 2023 amendment to the capital sentencing statute and the challenge to its lack of unanimity. So because those are pending in other cases, as we pointed out in the initial brief, and have been extensively briefed and argued already, I'd like to focus primarily today on the next point up, which is point 3, which deals with the victim impact evidence.
I'm sorry, you speak up just a little bit. I can barely hear.
I'd be happy to.
And I'm pretty good at hearing.
So the elephant in the room with victim impact evidence is this court's decision in Wyndham v. State. Now, I think it's worth noting that that decision was in 1995 under a different version of our capital sentencing statute, but it dealt with essentially the same argument. It's also worth noting that at the time, Florida's capital sentencing statute attributed a significantly less importance to the jury's recommendation. It didn't require a unanimous finding that any of the aggravators had been proven beyond a reasonable doubt, for instance. It didn't confine the jury to considering just those unanimously found aggravators. The recommendation was a simple majority, and I think maybe most importantly, the jury's recommendation of life was not binding on the trial court. We still had death overrides back then. But either because or for that reason and because of the merits of the underlying argument, we're respectfully requesting this court reconsider that issue. And the issue stems primarily from a conflict within our capital sentencing statute between paragraphs 2 and 8. Paragraph 2, which exclusively governs the jury's deliberations, sets out specifically what the jury can consider, which is limited exclusively to the aggravators that are found beyond a reasonable doubt and the mitigators that the jury believes to exist. Section 8, on the other hand, is bolted onto the end of the statute and permits the state to introduce victim impact evidence in a capital case. The problem, of course, is that victim impact evidence is neither an aggravating circumstance nor a mitigating circumstance. It's not among the things that the jury's deliberations are exclusively cabined to. And so because of that, we just have this prejudicial influence from a factor the jury can't consider. And the remedy that has come up has just been an instruction. The jury's instructed that they can't give aggravating weight to this evidence, that it's only being introduced for the purpose of demonstrating the uniqueness of the individual. But again, the uniqueness of the individual isn't something that's relevant to the jury's deliberations. They're expressly prohibited from considering anything other than the unanimously found aggravators and weighing those against the mitigators. This evidence, I think it's important to point out, is also always in every case going to be prejudicial to the defendant, and it's always in every case going to be at least somewhat impactful. It's not negligible. And I think the record in this case demonstrates the kind of the worst case scenario of what that looks like, where you have sobbing members of both the members of the public in the courtroom as well as members on the jury. This is the problem is injecting this kind of prejudice into the proceedings distracts the jury from what should be the focus, which is just what they're confined to determining, whether a death is appropriate based on weighing the aggravators against the mitigators.
So if we accepted your argument, what would be the basis for it? What are we going to cite? And what do you cite as the basis for deciding in your favor on this issue?
So the prejudice it's an Eighth Amendment prejudice because the presence of this undue factor creates the...
But okay, has the Supreme Court ever, U.S. Supreme Court ever said that? Or what's the U.S. Supreme Court said about this kind of evidence?
What they have said is that the jury's focus needs to be, or that anything that's going to distract the jury from...
What have they said about victim impact evidence?
Oh, well, so in Payne v. Tennessee, and I don't dispute that Payne v. Tennessee, or we're not trying to relitigate Payne v. Tennessee. But in Payne v. Tennessee, the United States Supreme Court held that the Eighth Amendment erects no per se bar to the introduction of this evidence. So we acknowledge Payne v. Tennessee, and we don't think that if this court agreed with us that holding would be in conflict with Payne v. Tennessee, because the issue isn't that there is a categorical bar on this evidence. The issue stems specifically from Florida's system, which is which is cabining the jury to not consider this evidence and then presenting it to them anyway. If Florida's sentencing
But our system, those are elements. Both are elements in our system. I'm
you're right.
I'm kind of lost, because if the Supreme Court says it's okay, I'm struggling to see how there's a pathway through here for us if there happened to be agreement with you, because I just don't see it.
Well, because it's not about the nature of the evidence. So this issue involves victim impact evidence, but it could be any other kind of prejudicial evidence that is not an aggravating circumstance or a mitigating circumstance. So the fact that Payne v. Tennessee said it's...
Part of the problem here is that Florida law specifically contemplates the presentation of victim impact evidence.
Yes.
And so it's not, you can't say it's in conflict with our statutory scheme. You may think there's tension between different elements of the scheme, but the scheme is the scheme, okay?
Yes.
And if the Supreme Court says it's okay, I'm struggling for any hook.
Well, I think it's important to distinguish those two things, because I agree that the scheme is the scheme. I agree that both of these things are present in the scheme. Our argument is that they're internally inconsistent, that if Paragraph 2 is exclusively governing these deliberations, and they're limiting them to the aggravators found beyond a reasonable doubt and the mitigators, and victim impact evidence is neither of those things, then it is an irrelevant factor that's being injected into that proceeding. So that the United States Supreme Court has held that if a state wants to determine that victim impact is appropriate for a capital sentencing jury to consider, the Eighth Amendment's not going to prohibit it. That doesn't foreclose this argument here, because you still just have this prejudicial influence. It is just as improper as an improper closing argument, or as irrelevant evidence, or as an invalid aggravating factor being presented to the jury. It is beyond the scope of what the jury ought to be considering. And because of how prejudicial and powerful this evidence often is, as the record in this case demonstrates, it creates that risk of undue influence. So
does your argument kind of necessarily depend on the jurors not following the instruction?
So the problem is that even the best instruction can't fix a bad statute, right? So a juror, first of all, I don't think it's even possible to ignore this type of evidence. It's, again, if it's resulting in jurors and members of the public in the court bursting into tears, it's just, an instruction is not going to, there's some bells you can't unring. We can't present this evidence to the jury and then proceed on the polite fiction that it isn't actually influencing them because we told them not to consider it. I think it's also worth noting out that this has to be incredibly confusing for the jury itself, because throughout this process, everything that's being presented to them is gatekept by its relevance to their ultimate determination. And then here they are at the end of the proceedings, after both the state and defense had presented their case, and they're told, well, now we're going to present you with additional evidence, but you can't consider it. And then they immediately go back to deliberate. And so injecting that kind of prejudice into these proceedings is what renders the system, or what creates this risk of arbitrary and capricious action, because you're now having this very emotional thing that's presented to the jury. And this was the underlying argument in Booth, but it exists here because the jury is prohibited from considering it. At the time of Payne, they were prohibited from considering it under Booth, but today they're still prohibited from considering it by the text of the statute. That's why the standard jury instruction is there and explicitly prohibits the jury from considering this evidence. So I don't think it does much good to say, well, they're instructed not to consider it, because even as we pointed out in the initial brief, even judges have difficulty not being affected by this, so that they recount being haunted by this evidence months later. So I think as trial counsel put it below, there's no human way possible to ignore just how impactful this evidence is. I mean, it is, and understandably so, right? I mean, this is among the most devastating emotional kind of thing that you can consider.
Do you want to address, speaking of confusing the jury,
sure.
Address the harmless error argument, especially in light of the kind of invitation
right.
of the death penalty?
Yes, Your Honor. So I'd say there's kind of two reasons why it shouldn't be considered harmless. The first is that this kind of error is, we believe, structural. So because the prejudice is in one form, the product or the resulting arbitrary and capricious imposition of the death penalty across all cases within the system. But even if we're limiting it to just this case, I think there's a few good reasons to not find this error to be, to not find this harmless, or to rather to hold that the state has not proven beyond a reasonable doubt that this is harmless. The first is that this was an 11-to-1 death rec, right? So while we can't get into the minds of each individual juror, we can't know what their decision-making process was. We know at the very least that at least one reasonable person viewed the mitigating evidence as significant enough to vote for life instead of death. I think at the second part of that is that, as I was mentioning earlier, victim impact evidence is something that is inherently compelling, right? It's inherently impactful, and it can't be considered negligible. And because it is also always going to be prejudicial to the defendant, we know that it moves the needle a little bit. And what we don't know is whether or not this evidence is what pushed a few of these jurors over the line from wanting to recommend life to recommending death.
But am I right that the penalty phase happened after the new law went into effect?
Yes.
So, I mean, from a harmless error standpoint, wouldn't you have to show not that it pushed a few, but that indeed it was dispositive to the sort of death majority? I mean, it seems like, to the extent you're making an argument, the timing of this argument, the timing of the penalty phase matters, because it isn't the same as if unanimity were required. Do you concede that, I guess I should say?
I don't believe so, Your Honor. And I hope that's not indicating how you're moving on points 1 and 2. But setting those aside, I think the question is just whether any reasonable juror would be moved from life to death by this evidence. Okay. Because we can't, there's no way of knowing if it's 1, 2, 3, 4, or all of them. If the reasonable possibility exists for a reasonable juror, then it's just as reasonable to expect that it's more than one. So I would not concede that it's that the number here is at play. If it were a unanimous death rec, I think that argument is a lot harder for me.
Right.
But because we have the one, I think that means that it is at very least a close call, right? It means that it is not the aggravators cannot be presumed to be so aggravating that they outweigh the mitigator in every case. So with that, I'll reserve.
I'm sorry to interrupt you.
Yes.
Could you remind me again, what does the standard jury instruction say about the victim impact evidence?
It says that the jury cannot give, you're about to hear victim impact evidence or statements from the victim's family about the resulting loss to the community, and that they cannot give that evidence aggravating weight, that it's being introduced solely to demonstrate the uniqueness of the individual and the resulting loss of the community from their death.
Okay. So, I mean, to the extent that your argument, though, is about the statutory scheme, I mean, it seems like for what you're saying, for it to be kind of irrational or kind of unavoidably contradictory, you basically have to read the subsection 2 stuff as if it's kind of a negative implication thing, like this is the only, like I understand that things can only be considered in aggravation that are the aggravating factors, but it basically says, you know, based on your consideration of the aggravators and the mitigators, this, but it doesn't say, I mean, when you have a later section that says you can hear this evidence, it's not saying, as long as your recommendation is based on that, it's not on its face precluding you from factoring in whatever way you think it's relevant, the victim impact evidence.
Well, respectfully, Your Honor, I would disagree. I think it is pretty clear from the text of the statute, because they're referring to aggravating circumstances, which are an enumerated list. They're finite. There's a set number of aggravating circumstances. And we know that this type of evidence can only be prejudicial to the defendant. It can only be aggravating. It certainly isn't mitigating evidence, right? So it's definitely not qualifying as mitigating evidence. If the only thing left is the aggravating circumstances are an enumerated list that are clearly defined, then it's just outside of it. I mean, the problem is that this is just a poorly constructed statute. It's not.
So what would you, how would you, if you, assuming that victim impact evidence is constitutionally permissible, and assuming you have a legislature that wants it, right, to be part of the process, how would you fix the statute?
The easy solution is just to present this evidence in Spencer. If this evidence is presented at the Spencer hearing, I think we can rationally assume that judges are going to be better capable of withstanding the emotional impact of this than a lay jury would. And in the instance of if the penalty phase results in a life recommendation, then you could have this presented at sentencing prior to the pronouncement of sentence, right? So it would still account for the state and victims' families' interest in speaking publicly in the case during the sentencing process, but it without compromising the jury's deliberations or infecting
But it's
the
not
jury's deliberation.
constitutionally impermissible for the jury to hear it and consider it.
No, Your Honor.
I'm just curious what your fix is that doesn't essentially take the jury out of the equation.
Well, you're saying that it's not constitutionally impermissible for the jury to hear it. I agree with that.
Okay, so
I think,
and the legislature wants them to hear it. So
Yes.
telling me that you can do a dispenser hearing doesn't solve that problem, right? Obviously.
I think the language of the Article 1, Section 16 and the language of Paragraph 8 both contemplate presenting this evidence to the jury. I think that goes, if it's prior to their deliberations, I think that goes too far. I do think it would be appropriate, and I think it's a rational compromise to have this evidence presented to, if it's presented to the judge, then it's at least being considered by the sentencer. If it's presented at the sentencing hearing, at least the public and the jury is still hearing it. It's also maybe worth noting that the statute doesn't require that they be presented with this evidence prior to their determination of whether to recommend life or death. So that's another way in which you can avoid this kind of conflict here. But where there is that conflict, I don't think that the state's interest in presenting this evidence at the sentencing hearing or a third party's interest in speaking at a defendant's sentencing hearing can override what ought to be the heightened protections in a capital case of their right to have the determination fairly decided based on the text of the statute and what they're required and prohibited from considering. So with that, I'll reserve the remainder of my time.
Good morning, Your Honors. May it please the Court, my name is Jonathan Tannen for the Attorney General's Office representing the state of Florida. The state is asking this court to affirm the conviction for first-degree murder and sentence of death for the murder of Deputy Joshua Moyers. With respect to victim impact evidence, this question has been settled by the United States Supreme Court in Payne versus Tennessee, which held that the admission of victim impact evidence does not violate the Eighth Amendment. As the Supreme Court explained in Payne, the purpose of this evidence and the reason the state has a legitimate interest in presenting the evidence is to remind the sentencer that just as the murderer should be considered as an individual, so too the victim is an individual whose death represents a unique loss to society and to his family in particular. And the purpose of that evidence is so that the victim is not treated as, in the Supreme Court's words, a faceless stranger at the penalty phase of a capital trial, that the jury understands this was a real human being whose death caused real harm not only to that person, but also to their family and their community. And this court, of course, is bound by the Supreme Court's ruling in Payne. And
could you address, I'm sorry to interrupt you, but could you address what because everything you just said is obviously true, but could you just address, like, what's your answer to what he's saying about the sort of, what tensions, inconsistencies, illogic, whatever you want to call it, about the way it's just set out here in the statutory scheme?
Well, I don't believe there is any tension in the statutory scheme, Your Honor. The purpose of the evidence is not as aggravation or mitigation. It's so that the jury understands the significance of the murder and the fact that the victim is effectively a real human being. And that sounds like a very simple point, but as the Supreme Court discussed in Payne, in the capital sentencing proceeding in a capital trial, the defendant has the right to present extensive evidence about their personal history, their background, and to have that considered as mitigation. And especially in a case like this, where the defendant presents very significant mitigation about their personal history, lengthy mitigation presentation.
I'm sorry to interrupt you, but his point is, I think he's saying that there's just textually, there's just a problem with, if you read this as kind of a negative implication situation, it says, based on the considerations in subparagraphs A and B, i.e. the aggravators and the mitigators, whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. And then it says you're also going to hear this other stuff. So I think I'm just curious, does this mean, should this be read literally that the recommendation is only supposed to be based on the consideration of those things? In which case it is weird then, why are you hearing anything else? Or is there a way to make it all fit together?
Well, that's everything you've said is correct, Your Honor, but the legislature has told us why the jury is hearing that evidence.
So it's not relevant to their recommendation?
I believe it is relevant to their recommendation. It's relevant so that the jury understands the harm caused by the crime of first-degree murder and by the loss of the victim. I think that's something inherent in the crime itself, not necessarily aggravation or mitigation. It's so that the jury understands why it's there to begin with and doesn't simply, write off the fact that there is a victim in this case as, treating the victim as essentially a name on a piece of paper or, again, a faceless stranger, to use the Supreme Court's words. And the legislature has told us what the purpose of it is. It's so that it's to demonstrate the victim's uniqueness as an individual human being and the resultant loss to the community's members by the victim's death. That's not necessarily aggravation or mitigation, but it is something the jury should keep in mind in understanding why it's there and the magnitude of its decision.
In a penalty phase, there's a lot of focus on the offender as a person. I mean, that mitigation is all about that. Aggravation is its own category, particular things enumerated. But I think what you can understand the legislature trying to do is you've got all this focus on and this just, I'm just repeating what I think you've already said. You've got all this focus on the defendant as a person, and that in that mix there should be some focus on the victim as a person, and that should not be lost sight of. Not that anything about the victim is going to be aggravating, but that reality is worthy of recognition and acknowledgement in this process.
That's correct, Your Honor. And the Supreme Court talked about that in Payne. In the sentencing proceedings, the defendant is entitled to present extensive mitigation, and the purpose of that mitigation, in large part, is to convince the jury that the defendant is not just the crime they committed. They're a three-dimensional human being, and every aspect of their life and character should be considered. And, of course, at the trial, at the penalty phase, the defendant is there and can sit in front of the jury. That's not true of the victim. If, without victim impact evidence, all the jury ever hears about the victim is that they were a person who was killed by the defendant. And this is what the Supreme Court explains in Payne. It's important, and the state has a legitimate interest in reminding the jury that this isn't just a name on a piece of paper. This isn't just a faceless stranger. This was someone who suffered real harm, and their family and community suffered real harm as a result of their death, and to treat them as a human being and not an abstraction. I would add as well that the court recently discussed this issue in Fletcher in a decision just issued this July, and pointed out that in addition to being bound by Payne, the Florida Constitution itself mandates the admission and consideration of victim impact evidence. Article 1, Section 16 states that the victim and the victim's family have the right to present victim impact evidence and to have that evidence considered in support of any sentencing recommendation. And this court pointed out in Payne that in light of that provision, the court is constitutionally prohibited from granting, in that case, Fletcher's request to have victim impact evidence declared unconstitutional. I would just address Mr. McDowell's counsel's point as far as the impactful nature of the victim impact evidence in this case. I believe the argument is solely that victim impact evidence itself is unconstitutional. The defense did not object in this case to any of the victim impact statements before they were read, and the defense did move for a mistrial based on the allegedly emotional reactions by some jurors to the victim impact evidence, the trial court ruled that the behavior of the jurors was appropriate. It determines that a mistrial was not warranted under the circumstances of this case, and that decision has not been challenged in the initial brief. So the sole issue before this court is whether victim impact evidence is unconstitutional, and that issue is controlled both by Payne and by the text of the Florida Constitution. Does the court have any additional questions about this issue or any of the other issues in the case? In that case, I will rely on the state's answer brief for any further points and request, again, that this court affirm the conviction and sentence. Thank you, Your Honors.
Thank you.
So just a few points in rebuttal. First, as opposing counsel pointed out, the United States Supreme Court in Payne did mention what the relevance of this information, of this type of evidence was. And I agree that it's relevant in the abstract. The issue is whether it's relevant to in Florida's system and whether it is whether it's appropriate for the jury to consider it or whether it's outside of the scope of their deliberations. And we think it is based on the text of the statute, based on the fact that the jury is admonished to not consider this in a standard jury instruction, and because it's not, it simply isn't an aggravating factor.
I mean, but just to be fair, I mean, it's the instruction I thought you said is that it can't be considered as an aggravator, right?
Correct.
And so that's kind of a term of art, as meaning that can't be sort of the basis for making you eligible, and then that's going to be weighed. I mean, it mean, it seems like the jury's hearing all kinds of stuff, and the things that they hear, they don't necessarily have to fit in logically into being labeled either an aggravator or quote unquote mitigation. I understand. I think textually it is interesting. It is weird to say you can hear A, B, and C, but then based on A and B make your recommendation. That is, I mean, so that's almost more of like a drafting type problem than injecting some inherent kind of unfairness to the point of unconstitutionality into the process.
So, well, a few points. One, I think the logic that you just described about why, well, the jury's hearing all sorts of things, not all of them are inherently, tied intimately to the aggravator. Why is this a big deal? I think that argument would make a lot of sense in a system where we had a catch-all aggravator that involved the circumstances of the crime. I could see an interpretation of victim impact evidence falling under a broad catch-all kind of
But I don't know, but that wouldn't, I mean, in terms of the legal purpose that aggravators serve, I don't know if you could ever have, I don't think you could, if the point is to narrow the class of people who are eligible, if that's the legal work that aggravators are doing, I don't know if you could say, aggravator number 14 is, do you unanimously agree beyond a reasonable doubt that there's some other unspecified thing that makes this person eligible for the death penalty. I mean, that's kind of not what I mean, I don't need to tell you.
Well, it depends. So I think you're right, but it depends on. So when states are constructing a capital sentencing statute, there's two general parts to it. There's the eligibility phase, which is what you're talking about when you mention, well, this is just kind of the initial threshold thing that needs to be met, and you can't have something too broad, otherwise all offenses would qualify. But other states also have, when they get to the weighing stage, because there are jurisdictions that are considered weighing states, others that are considered non-weighing states, and Florida is a weighing state. Florida has a set number of aggravators, and the jury is not permitted to consider anything other than those aggravators. In a non-weighing state, which is what I was referring to, you could have a situation where the jury is permitted to consider in the selection phase, which is basically at the conclusion of penalty when they're determining whether to impose life or death, the jury can consider any other aspects of the crime. But we don't have that system in Florida, and I think that's what distinguishes this from the logic that you're putting, which would make sense in the abstract, but not here. And again, this is just resulting from the fact that Florida statute cabins the decision-making exclusively to the aggravators and the mitigators. I think it's also, as we mentioned earlier, victim impact evidence can still be presented at the sentencing hearing before the pronouncement of sentence, or to the judge in the event of a death recommendation. It could be presented at the Spencer hearing. So there's nothing that would the victim's family's interest in presenting this evidence, you wouldn't be violating their right to present this at sentencing if it's occurring during the sentencing hearing. And for the same reason, in the non-capital context, if you had a case, for instance, that had a minimum mandatory, let's say their PRR, and they're going to get 30 years no matter what, it doesn't violate the Article 1, Section 16 for the jury to speak at sentencing about the way that the loss has impacted them, or the victim to speak at sentencing about how the offense impacted them, because the sentence is just as already decided in that case as it would be in the case of a life recommendation. So I think the compromise here is just to either present this after deliberation, or to present this after deliberations, and whether that be before the pronouncement of sentence or at Spencer, I think that fixes the real problem here, which is the impact on the jury's ultimate determination in a capital case. I think opposing counsel mentioned that this wasn't objected to below. We did request that we did request what I was just suggesting, which is that the victim impact evidence be presented at the Spencer hearing, and that was rejected. And I think I'll close with the point about Payne being controlling. I respectfully disagree that Payne is controlling here. Payne deals with whether or not the Eighth Amendment generally prohibits a state from determining that victim impact evidence is relevant for the jury's consideration. That is not our system. Paragraph 2 is the only paragraph that in our capital sentencing system that governs what the jury can and can't consider. It sets out exclusively the aggravating circumstances in the preceding paragraph. It limits the jury's, or it prohibits the jury from giving aggravating weight to anything other than the aggravating circumstances. And we know for a fact that this isn't a mitigating circumstance. So we have this, we've poisoned the well essentially for every deliberation in a capital case in Florida by permitting this very prejudicial evidence, by permitting this evidence to be presented immediately before the jury retires to deliberate. So for the issue that we raised in point 1, though it wasn't discussed this morning, we'd request this court remand for the imposition of a life sentence. And for the remaining points, I respectfully request this court vacates his sentence and remand for any penalty phase.
Thank you. We're adjourned.
All rise.